Welcome to this PHR-SPHR certification class Learning Bite. In this Learning Bite, we'll learn what adverse impact is, how adverse impact rates are used in affirmative action and discrimination lawsuits, and how adverse impact rates are calculated. So let's begin. First, what is adverse impact? Adverse impact occurs when a decision, practice, or policy has a disproportionately negative effect on a protected group, even though the adverse impact may be unintentional. The EEOC guidelines and the Uniform Guidelines on Employee Selection Procedures define adverse impact as a substantially different rate of selection in hiring, promotion, or other employment decision which works to the disadvantage of the members of a race, sex, or ethnic group. When adverse impact exists, an organization may be vulnerable to charges of discrimination. The agencies have adopted a rule under which they will generally consider any group's selection rate that is less than 4/5 or 80% of the selection rate for the group with the highest selection rate as a substantially different rate of selection. This 4/5 or 80% guideline is not intended as a legal definition, but as a practical means of keeping the attention of the enforcement agencies on serious discrepancies in rates of hiring, promotion, and other selection decisions. The Supreme Court of the United States first described the disparate impact theory in the 1971 case of Griggs versus Duke Power Company. Prior to the passage of the Civil Rights Act of 1964, Duke Power Company had a policy of segregating employees according to race. Specifically at its Dan River plant, African Americans were allowed only to work in the labor department, where the jobs were among the lowest paying positions in the company, rather than in one of the four operating departments. After Title VII of the Civil Rights Act of 1964 passed, the company changed its policies, adding a requirement of a high school diploma or a minimum score on an IQ test for positions in areas other than the labor department, thus eliminating a large number of African American applicants for positions outside that department. The court found that under Title VII, if tests disparately affect ethnic minority groups, employers must demonstrate that such tests are reasonably related to the job for which the tests are required. Based on this decision in Griggs versus Duke Power, Title VII now prohibits employers from using neutral tests or selection procedures that have the effect of disproportionately excluding persons based on race, color, religion, sex, including sexual orientation and gender identity, or national origin if the tests or selection procedures are not job related for the position in question and consistent with business necessity. This is called disparate impact or adverse impact discrimination. The Uniform Guidelines on Employee Selection Procedures. In 1978, the U.S. Civil Service Commission, the U.S. Department of Labor, the EEOC, and the U.S. Department of Justice jointly adopted the Uniform Guidelines on Employee Selection Procedures to establish a uniform standard for the use of selection procedures by employers and to address adverse impact, validation, and record-keeping requirements. The Uniform Guidelines document a uniform federal position in the area of prohibiting discrimination in employment practices based on the color, race, religion, sex, or national origin of the individual. The Uniform Guidelines outline the requirements necessary for employers to defend their employment decisions based on overall selection process and specific selection procedures. The EEOC provided additional interpretation of the Uniform Guidelines 1 year later. Though clearly an older regulation, employers should not dismiss its importance. The Uniform Guidelines continue to serve as a unified stance for all federal agencies, and they apply to all aspects of selection, including testing, educational requirements, physical requirements, and evaluations of work samples or performance, to name a few broad categories. The basic principle of the Uniform Guidelines is that a selection process that has an adverse impact on the employment opportunities of the members of a race, color, religion, sex, or national origin group, and thus disproportionately screens them out, is unlawfully discriminatory unless the process or its component procedures have been validated in accord with the Uniform Guidelines or unless the user otherwise justifies them in accord with federal law. This is the principle adopted unanimously by the Supreme Court in Griggs versus Duke Power and was ratified and endorsed by Congress when it passed the Equal Employment Opportunity Act of 1972, which amended Title VII of the Civil Rights Act. Though the uniform guidelines are not legislation or law, they are relied on by courts as a source of technical information and are typically given significant weight. The 4/5 or 80% rule is the simplest and most common way of estimating adverse impact. The uniform guidelines indicate that the 4/5 rule is the preferred method for determining adverse impact unless samples are very small or very large. The 4/5 rule prescribes that a selection rate for any group classified by race, color, religion, sex, or national origin that is less than 4/5 of that for the group with the highest selection rate constitutes evidence of adverse impact, also called disparate impact. That is, discriminatory effects on a protected group. Adverse impact may occur in any of the organization's decisions related to employees, be it hiring, promotion, training, termination, transfer, or layoff. A particular test or selection procedure must be evaluated for effectiveness in terms of selection based only on characteristics relevant to the job or task. For instance, if a company hires 50% of male applicants for a position in a predominantly male occupation, but the rate for female applicants is 20%, there could be an issue of discrimination as the rate of hiring women is only 40% of that for male applicants, thereby violating the 4/5 rule. Also known as the 80% rule, a practice may be deemed statistically non-discriminatory if the adverse impact rate is 80% or more. In the previous example, the selection rate of women to men was only 40%, well below the 80% threshold. Let's look at the four-step process to determine adverse impact in the hiring selection process. First, calculate the rate of selection for each group. Divide the number of persons selected from a group by the number of applicants from that group. Second, determine which group has the high selection rate. For positive personnel transactions, the highest rate is the most advantageous. For negative transactions, the most favored group has the lowest rate. Third, calculate the impact ratios by comparing the selection rate for each group with that of the highest group. Divide the selection rate for a group by the selection rate for the highest group. Fourth, observe whether the selection rate for any group is substantially less, i.e., usually less than 4/5 or 80%. Then the selection rate for the highest group. If it is, adverse impact is indicated in most circumstances. Let's look at an example. In this example, we have 80 Caucasian and 40 Latino applicants, of which 48 Caucasians are hired and 12 Latinos. Is there possible adverse impact against Latinos in our selection process? To answer this question, we'll calculate the adverse impact rate. Following the four-step process, we'll first calculate the selection rate for each category. The selection rate for Caucasians is 48 hires divided by 80 applicants, which yields 60%. The selection rate for Latinos is 12 hires divided by 40 applicants, which yields 30%. Second, identify the group which has the highest selection rate. In this example, it's Caucasians with a 60% selection rate. Third, determine adverse impact by dividing the selection rate of Latinos to that of Caucasians. 30% divided by 60%, which yields 50%. Since this is below 4/5 or 80%, it is possible evidence of adverse impact on Latino applicants. Let's give you a chance now to practice calculating adverse impact rates. Given the following selection data, calculate the adverse impact ratios and determine if adverse impact exists for African American and/or Latino applicants. Pause the video while you work on your calculations. Possible adverse impact has been determined for African American applicants since their impact ratio is 66%. Possible adverse impact was not found for Latino applicants since the impact ratio was 89%. Great job. Now, while we cannot guarantee or predict if you'll have any math calculations on your exam, calculating and interpreting adverse impact ratios is an important skill to possess as an HR professional. Be sure to see our other learning bites for more math calculations, such as compa ratio, overtime and blended overtime pay calculations, and yield rates. And again, I wish you the best in your exam preparation.